taking my time. Taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if you can hear me. I'm just waiting. There's a delay. Like, why is she not responding? I'm waiting. Okay, nice. Okay, I'm gonna do quick greetings on this one, and we will get into the article, and then we're gonna watch the attorney from the channel called The Lawyer You Know and his dad go over the motion filed by Attorney Steele on why this new judge needs to. She can't do it. She can't do it either. She needs to go. So okay, so. Hey, Bam Bam, first in the building. How you doing, Bama girl? Hey, my sweet sis, 41 Fit, who is a content creator and part of the Mod Squad. 41 Fit, I just finished episode 4. My eyes watered, okay? We got some things to talk about. Hey, and I'm talking about House of the Dragon. Hey, Pink Hearts Forever, number 6 on the likes. Thank you. Hey, Miss Cheryl Tuff from Seattle. I can't get my hiccups out. Hey, CC. All right. Okay. Let me bring up this article first, read that, and then the details and reactions we'll get into with the Lawyer You Know. Okay. Oops. Well, there's that. 1 second. Okay. It says judge denies motions to recuse herself from deciding fate of Young Thug's judge. It says Fulton County Judge Rachel Krause has rejected YSL defense attorney's motions to remove her from deciding the fate of the judge overseeing Young Thug's internationally watched criminal trial. Krause's ruling, issued late Wednesday, means she is still on track to determine whether Fulton County Superior Court Chief Judge Judge Glanville should be recused from continuing to preside over the case. For months, defense attorneys for Young Thug and his remaining co-defendants have been making motions for a mistrial, claiming Glanville is biased against them and their efforts to prove Jeffrey Williams, Young Thug's real name, is not the head of a criminal gang known as YSL, Young Slime Life, or Young Stoner's Life. Prosecutors, on the other hand, want Glanville to remain as judge, as evidenced by their responses to defense attorneys' efforts that came late Wednesday afternoon. Krause's ruling came in response to a motion filed this week by Young Thug attorney Brian Steele, which called for Krause to recuse herself from making the decision on whether Glanville should stay on the YSL case. In the motion, he also called for 2 top prosecutors to be removed from the trial. At the center of the trial's latest delay is a June 10th, 2024 ex parte meeting held between Glanville, two Fulton County prosecutors, star prosecution witness Kenneth Copeland, aka Lil Woody, and his stand-in attorney Kayla Bumpus. The legal term ex parte, translated from Latin as out of the party, refers to a decision made by a judge without requiring all parties in a dispute to be present. Last week, Glanville released that meeting's timeline and transcript, partial transcript, a meeting which later that day resulted in Young Thug's attorney Brian Steele being held in contempt of court. On June 7th, 2024, Copeland himself was jailed for refusing to testify. Copeland is widely believed to have informed police of alleged crimes committed by Young Thug and the alleged YSL gang. By the following Monday, Copeland had changed his tune and agreed to testify. Then Glanville ordered Steele be held in contempt after Steele told Glanville in open court he had learned of the ex parte meeting that was held without any other defense attorney's knowledge or forewarning. Glanville demanded to know how Steele had learned of that meeting, and Steele refused to disclose his source. That's when Glanville ordered Steele arrested. Steele and Young Thug's other attorney, Keith Adams, have repeatedly moved for a mistrial, as have attorneys for some of the other defendants in the trial. Glanville had been denying all of the repeated motions, as well as motions from Steele and other attorneys to recuse himself from the trial. Prosecutors and defense attorneys are continuing to haggle over Copeland's police interviews and jail recordings. Steele is accusing prosecutors of coercing Copeland's testimony, who he said was being surrounded by law enforcement and district attorney officials. Williams was arrested on May 9th, 2022, along with 27 other suspected gang members in Buckhead as part of a 56-count indictment. The trial's jury selection lasted longer than any other in Georgia history, and actual witness testimony itself will likely surpass state records. Both records were set by the Atlanta Public Schools teacher scandal trial of 2014 through 2015. Prosecutors are attempting to show YSL is a criminal street gang responsible for numerous offenses. Defense attorneys say YSL is not a gang, but simply the name of a record label. Young Thug himself is facing 8 criminal counts under a federal law that was originally enacted to fight organized crime. Georgia is one of 33 states that has its own RICO law, but in the Peach State, the alleged criminal enterprises do not have to have existed as long as the federal law. The trial, which has been repeatedly plagued by arrests, charges, and disruptions, began on November 27, 2023. Defense attorneys have repeatedly raised concerns that the trial could go on for years based on the number of witnesses the state plans to call up. Williams is also charged with possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, possession of a firearm, and possession of a machine gun. A total of 18 jurors have been selected, with 6 of them being alternates. 2 jurors have already been excused. 1 had a medical emergency, and the other moved out of Fulton County. Okay, so now let's get to our lawyers, because I like how they'll stop and talk about what they're reading. I really appreciate that. So we're gonna go ahead and watch them. Let's see here.
What's up, everybody? Hearing up those 35 pages. The second document we're going to read is the state's.
Okay, it automatically started, but just to let y'all know, I will interrupt it because I have to add my own commentary and critique and everything. Okay, so hey, everyone that has come in. I see Tia P, number 14. Too Blessed for You, Flower Bloom, Maria. I see y'all. Hey. Okay, let's go.
Response. This was filed on July 8th. The state's response was filed yesterday. There's a bunch of attachments. We can go through kind of what those are, Dad, as we go. But this motion itself is 26 pages. The other one's 9. We're going to read those 35 pages. Not all the attachments, of course, because we don't want to be here for hours and hours just reading and reading. But we've got a lot to discuss. We'll follow along and keep track of your questions to make sure we answer a ton of those on the way as well. So first comes now Jeffrey Wilson's a lawyers. Okay. This is the first footnote. This motion applies to lawyers Love and Hilton, in addition to Judge Glanville, as all 3 are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. This motion also timely moves to recuse the Honorable Judge Krause based on the fact, so this is the judge that would be hearing Judge Glanville's recusal motion and deciding whether Judge Glanville will be off the case or not. And we already talked about how this judge is within the same jurisdiction as Glanville. So why do they want to recuse Krause? Because she sits on the Fulton County Superior Court bench with Judge Glanville, and in April 2024, which was just 3 months ago, and in the middle of this YSL trial, Glanville contributed $2,000 to her campaign. And in April, she donated $500 to his reelection campaign during the trial.
Okay, first stop there, because that's so important. Remember, if y'all have been following it, y'all know that everyone is like, please let the judge that is deciding if Glanville needs to recuse himself, please let them not be out of Fulton County. Do not let them sit on a bench in Fulton County. So not only are they coming out of Fulton County, but as he said, they both contributed to each other's campaign funds. No, that's not good. That's not good. That's not good. And she's on the thumbnail too. Depending on, I don't know if he'll go over her background or not, but depending on how this goes, we might go over her background. But yeah, this would be a bad idea.
Undersigned counsel derives no happiness, says Steele, saying, this doesn't bring me any pleasure to file the supplemental motion. However, let justice be done, though the heavens fall. And actually, the heavens will not fall by unmasking biased and unethical members of the Florida bar, starting out with heat. How unusual this is.
You slipped Florida in there. You didn't mean to say that.
Oh, did I say Florida? Members of the bar. Sorry, not Florida.
Yeah. Okay. This is the motion to recuse is not that unusual. It happens, regularly. However, as we go through here, the things he says and the venom, I don't know if it's the right word or not, but these are very strong words he's using against the judge. And the fact that he went back and had somebody look at all the contributions that these judges had for their reelection campaigns and found these contributions, it was like a gold mine when they found them, because you don't see this very often. At least in Florida, you wouldn't see one judge contributing to another and then the other judge contributing back.
Whitney is saying that a new one has come out, and it says that only Glanville donated to her, not the other way around. So
she didn't donate
now with that edit. So maybe they didn't give to each other.
Because he says it again in the motion.
Yeah, I know, but I think they're saying that another one came out where that's redacted. So people are saying, have you seen Krause's response? We're going to read the two newest documents we have today. If there's more, we'll do another video on it, because we got all the time that we're going to need just to read through these two documents. So here we go. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed if it's within 5 days that the affiant learned of the alleged grounds for disqualifications, including Saturdays and Sundays. This supplemental motion is timely, and he makes a little bit of an argument there. This timely filed supplement to the motion to recuse has also been timely presented to the Honorable Judge Krause and Glanville. In the case at bar, Judge Glanville's ex parte communication with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives of the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. Okay, only partially captured, but we know from the Bumpus video that it got everything that was material and important, but nonetheless, maybe it was not the complete transcript. Glanville, lawyer Love, and Hilton have prejudiced and tainted Mr. Williams' trial so deeply, as Glanville has not acted as a judge, but morphed into an essential part of the prosecution team.
Ooh, I like that phrase, because it does seem, although I know I came in the middle, so I'm going to have to go do my due diligence and try to go back. But from what I could see, and I got to get that video from, I think it was Valencia that sent it, where she was saying there was a video where it looked like they were signaling each other. But yes, morphed into an essential part of the prosecution team seems so appropriate, because that is what it looks like. Like the motions, they didn't even have to fight for objections, coming from defense, because the judge would seem like he was doing it for them. It's been looking real skewed over here to me, and I'm more new into it. I get that, but it looks real skewed. And then the way he was more concerned about who told about the ex parte, but not also acknowledging that it wasn't handled properly. That was like it seemed to me he got like emotional about it, and not just it was about things staying private. They're supposed to stay private and all this other stuff. But yeah.
The judge's conduct, including ex parte communication with the prosecutor during trial, resulted in the appearance of bias, requiring reversal of the convictions and sentences. And that's a case that he cited. Mandate USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Yet Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to these meetings as privileged and described the improper secrecy as sacrosanct. And there's a footnote here. Sacrosanct means most sacred or holy, inviolable, immune from criticism. As shown herein, communications immoral and unethical, diametrically opposed to sacrosanct. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. A lot of
Okay, so I'm going to stop there because I did grab the video that it was Valencia that she sent me to show how this is just one of the ways he looked to be an essential part of the prosecution team. So let me mark my timestamp on here just in case it stops. And I can go back to it. Okay, so it's very quick, y'all. It's a few seconds. So if you're able to look, I'll try to make it bigger too so y'all can see it. Okay, here it goes. The text says, "What is this? Judge sends signal sign to prosecute." I think they meant prosecutor. And it's just speculation. It's alleged. But there's this where she's rubbing her ear and then he like does a thing with his ear. So just, okay, I'm going to start it over. But here y'all go. And she nods. That's the thing too. Like she nods when she touches her ear. And he's looking right at her. He's touching his ear. Now she touches her ear. They're zooming in. I think they just replaying it. Yeah. It's like he's looking right at her again. I'm not, now, obviously, some things can be coincidence, but that it was weird. It's weird. That's all I'm saying. It's weird. Okay. Signaling like a baseball player, 41 fit. And hey, Shan. Hey, April with the 2 L's. Okay, I'll put the video back up. But just wanted to show y'all that.
Repetitive from some of what we've seen in other motions. Is there anything that sticks out to you there as additional?
No, nothing new. In fact, this motion is very repetitive as we go through it.
All right. He timely raised the objections. Canon Rule 2 of the Georgia Code forbids a judge from considering ex parte communication, as judges shall accord every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Glanville embraced his view that the communication at this ex parte hearing were privileged. The judge shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultation with experts, or counsel, personnel, and settlement conferences. It's also clear that ex parte communications are presumed to have been made in error. And once a party has shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication.
Real fast, if you just came in, what the lawyer is reading is the motion filed by Attorney Steele, who represents Young Thug, about why this judge, this disqualification judge that was chosen, Judge Krause, should not be the disqualification judge to see if Glanville should continue on the YSL trial.
That's an important word.
In this case, sorry, the lawnmower is like right outside my door. I don't know if you guys can hear that.
Well, the word harm is important, and your viewers should remember that, because harmless error is important. So it can be harm, it can be wrong, but if it's not something that makes a difference, they can still not reverse or not recuse based on it. So the word harm there is very important. We'll see that as we go through these motions.
All right, we'll continue. In the case at bar, there is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications as captured in Exhibit B resulted in harm. Mr. Williams' case should be reversed on direct appeal if there is any conviction and sentence. And he compares other cases. As shown in the joint affidavit, here too as Exhibit A, Glanville not only conducted this improper and unethical ex parte meeting, Glanville therein acted as an advocate for the Fulton County District Attorney's Office as he dispensed legal advice and supported lawyers Hilton and Love. Their goal to have Mr. Copeland testify against Mr. Williams and the co-indictees. And he attaches their joint affidavit and the exhibit of the entire transcript, which we've read through together. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Okay, those are more strong words. Judges shall disqualify.
He's going to drive that point home. It's hard to see how Judge Glanville is not a part of the prosecution team. He's going to drive that phrase home.
By themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of a disputed evidentiary fact concerning the proceedings. Judge Glanville has been derelict in his judicial duties and must be recused. Once evidence of the illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon, lawyers Hilton and Love sat mute, while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. And we're about to read the state's response, and it's amazing how they view this ex parte hearing and how they view what happened with Mr. Steele, which we'll get to when we read that part of the response.
Oh, that's okay. That's interesting. Okay, so the sentence that he read was in open court in in the afternoon of June 10th, 2024, in open court, lawyers Hilton and Love sat mute, and Hilton and Love will be the prosecutors, while Judge Glanville found the undersigned counsel, which I'm sure would be Steele, in contempt of court and sentenced the undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. So what sentencing was he trying to give him for contempt of court? Because he said the longest possible time in jail. What is that? I know they have to be dramatic to drive their points a lot of times and everything. I just wonder what is the longest time for contempt of court. I might have to Google that while we're watching them.
But he is making, he's holding back nothing, saying all I did was point out illegal, improper, and unethical conduct by this judge and these lawyers. In addition to violations of Georgia rules of professional responsibility, which would carry penalties up to disbarment, felony crimes, such as violation of oath of offices codified in OCGA. So potentially Steele will I don't know if he has referred them or made a complaint with the Georgia bar. Melnick and Bumpus, I believe, said they hadn't at this point. But it kind of sounds like that's where Steele's going.
Right. And he's probably going to ask somebody to investigate them for criminal activity. But the problem is the state attorney's office is the same state attorney's office they belong to. So the person he'd have to go to is probably the Attorney General of Georgia.
And we've seen similar things happen in other cases. All right, we're going to skip a paragraph ahead to this one. In the case at hand, the state cannot show Judge Glanville, lawyer Love, or Hilton's intentional and willful complicity in these ex parte communications was harmless error. So he's saying it was not harmless. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his two cohorts, calling them cohorts is quite the verbiage, from the Fulton County District Attorney's Office on Mr. Copeland's changed Mr. Copeland's stance not to testify against Mr. Williams.
Ooh, okay, we're throwing in the word cohort now. But it looks like this is from the Edwards Law Group is saying 20 days maximum. I'm going to see a second source to see if I can find it somewhere else, but they're saying 20 days is the maximum. So I guess he would have been sentenced to 20 days held in contempt of court or into jail for it. Ugh. Hey, Miss Cutie Pie, and hey, Paper Chase.
If Mr. Copeland refused to testify, all of his prior false inculpatory statements as to Mr. Williams would not come into evidence based on Mr. Williams' constitutional right to confrontation. Intimidations, tactics thrust upon Mr. Copeland by the combined work of Glanville, lawyer Love, and Hilton resulted in Copeland's decision to testify. So talk for a second about what he means there. So if Copeland never testifies, we know about all this other stuff that Copeland is saying as a lie. I made it up. I actually committed a bunch of those crimes. Well, in the past, he does pin it on some of the co-defendants that are here on trial. So if he doesn't testify, they're arguing that helps the defendants immensely. So explain why that is.
Well, if he doesn't testify, then they can't impeach him. And what they're doing is bringing in prior inconsistent statements when they're putting in these videos, saying, look, he's saying this now, but then when he was being interviewed by the police, he said this. And those prior inconsistent statements can come in if he testifies. If he doesn't testify, then there are no statements to be inconsistent with. So they can argue that those videos of the interviews with the police cannot come into evidence.
And when you say they, you mean the state. The
Right.
state doesn't really care. And that's why, and that was very clear in the ex parte meeting. They don't care what he says. Get on the stand, lie, don't lie, say you did certain things. We don't really care. We got to put you on the stand so they can cross-examine you, so we can play all these videotapes where you say all this bad stuff about the defendants, which again, testimony against the defendants that people have made in prior police interviews, especially snitches or people that flipped or whatever it may be, is appropriate. It's fine. It's fine for prosecutors to use that. But in this situation, it seems like they went above and beyond to try to make something happen and cross the line when they had these ex parte communications. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, lawyer Love, and Hilton's improper, unethical ex parte meeting with Copeland. Moreover, the cover-up, like you said, the cover-up is worse than the crime. The cover-up, secrecy, and silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three public officials, in quotes, simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue the trial as if nothing out of the ordinary occurred just hours and minutes before.
Ooh, y'all know I love a good narration from an attorney. So I do like how he wrote this up, and the fact that he's calling it a cover up, he called them team members, like 41 said, he might as well say cronies. And then saying that they feigned to continue trial as if nothing out of the ordinary occurred just hours/minutes before. Ooh. Now, just so you know, if you're coming in, the judge denied this motion, but I feel like someone else should be looking outside of Fulton County at this.
Keep in mind,
YouTube. Sorry, go ahead.
No, that's right. I'm just saying that, you keep in mind that he is thinking of how many ways can he say that there's a conspiracy between these three. He's using different words in different paragraphs saying the same thing. In this case, he's using the word the three public officials, the three team members. He is really emphasizing it, right? He's really emphasizing it to the appellate court or to whoever judge hears this, to whatever judge hears this, to make sure the judge doesn't have any mistake about what Mr. Steele is saying.
Yeah, I mean, it really is. It's about as disrespectful as you can be with a lawyer in a respectful, pleading, because he's basically taking every shot he possibly can at Glanville and the prosecutors. But I thought it was very interesting that they cited YouTube and put the link in there and put literally the timestamps. The fact that this is becoming so commonplace in legal documents now is really wild, really wild. Crazy Cat Queen said she introduced a bunch of criminal classmates to you and we're watching you live. Can we get a go Knowles for my classmates and a few lawyers? Go Knowles. Are you telling me you're at FSU College of Law right now? That would be wild.
Oh, that's great.
Georgia and in America has been attacked by the conduct of these three actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for lawyer Love and Hilton to be removed and disqualified from Mr. Williams' trial, and Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of lawyer Love and Hilton.
Okay, again, we're seeing where Mr. Steele has found another way to say it. These three actors, now Now they're actors. Now they're cohorts, team members. And then he's bringing in, which is interesting, not only the state of Georgia, but the entire country is affected by the actions of these three. So he's really putting as much emphasis, he's really building it up here.
I wonder too, with him using the word actors, if he's like the lawyer that wrote this, if they're saying like, how you call someone a bad actor, not like they don't know how to act, like they can't, like they're literally like cheesy acting, but in the sense of when something happens or something does something in bad faith, they call them like bad actors. I wonder if that's how the attorney's using the word actors in this case. And Shan clarified this is not the motion that's denied. The motion that's denied will be the one asking the judge to recuse themselves. And there was something else you wrote. I would think, I guess she can, she already has denied it, but I just would think that it shouldn't be a judge in Fulton County, donations or no donations, but I would think in Fulton County and then donating to a campaign, whether she did it for his campaign or he did it for her campaign, it does seem like that's a bit much to make a decision, to be able to be the one to make a decision. Oh, okay, more choice words. Okay. Yeah, bad actors. Right. Not like you act in a theater, but literally. In fact, let me look up the definition of what I'm talking about. Because I'm not talking about acting in a movie and stuff like that. Yes. Okay. It's a person, group, country, etc., who purposely and usually repeatedly engages in very bad behavior, such as committing crimes or causing harm to others. That's how I took it, how the attorney meant it. That's how 41 Fit took it too. Right. It should not be a judge in Fulton because he's their supervisor. Right, Shan?
And he's not wrong.
No.
I mean, he's not wrong. The world is watching. This can't be how it is. If this just gets swept under the rug and we keep going forward and, we make some excuse about what people think about the defendants or what people think about the lawyers or whatever, and we just keep rolling, that's really not a good look for the justice system across the nation. It really isn't. The judges must scrupulously avoid improper ex parte communications, whether or not they consider them. The judge has an ethical duty to recuse himself sua sponte anytime he's aware of grounds to do so. We know Glanville didn't do that. He did the opposite of that, as they argue in this motion. No hearing is actually needed to reach the finding that recusal of Glanville in Stanter is mandated. Glanville has automatically caused his recusal and disqualification from Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting the affiant's allegation of judicial bias. I don't know if I agree with him there. Do you agree with that statement?
No, I don't.
I think it's just, that's a bridge too far, maybe potentially, but he's going
he's got to make these allegations because he doesn't know what the response is going to be like either. So why not throw everything he can?
Mr. Williams respectfully requests a hearing as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witnesses to fully unmask this above discussed misconduct, as well as further misconduct that may have occurred. Again, a lot of this is getting a little repetitious. We're about halfway through almost. The judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County District Attorney's Office, and stains courts throughout the state of Georgia and the country.
And the country again, yeah.
What occurred in the Star Chamber outside the view of the cameras in the shadow and hidden from Mr. Williams and his counsel is unpardonable.
Not in the shadows, not cloak and dagger. Oh my gosh. I'm telling y'all, I know the trial is serious, but again, when someone has a flair for writing, I get excited. So the phrases are just over here. They're just over here like, I don't know how to put it, but I'm very intrigued. Okay, I'll let it keep going.
And a violation. I mean, he's going off the top rope. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threats when courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. It's a pretty good quote for what they're trying to do here. They conducted their illegal and unethical conduct outside the view of Mr. Williams and the public, outside the lens of the camera. They are public officials doing this. They should never be trusted by Mr. Williams or his counsel.
Okay, because they use the phrase star chamber procedures or proceedings, just so we are all on the same page. Star chamber proceedings, any judicial or quasi-judicial action, trial, or hearing which so grossly violates standards of due process that a party appearing in the proceedings is denied a fair hearing or a fair trial.
As sworn to in Exhibit A, Judge Glanville, Lawyer Love, and Hilton conspire to conceal and suppress Brady material. The Star Chamber cannot prohibit Brady evidence from coming forward. That's exactly what Glanville and the lawyers planned to do. Again, I mean, I actually think that is a pretty good argument. If they wouldn't have been called out.
No, go ahead. It is, because remember, we have to show harm. And here we're showing a constitutional harm. Brady's a constitutional case saying that the state, everybody must turn over anything they know about exculpatory evidence to the defense. So if they can connect this ex parte hearing to the fact that they're withholding Brady information, it makes it a constitutional violation. They've really done a good job of establishing their harm.
Right. And the reason for that is knowing that this guy was going to potentially say he committed some crimes that the defendants would have been charged with is like literal prototypical Brady. It is like the third party culprit that they might want to point the finger at, regardless of the involvement in the gang stuff and whether or not, he's involved or trying to help him or whatever. That is Brady evidence that the defense has to know about and has to be able to present to the jury.
If they win this argument too, what's so interesting is we're watching precedents, not precedents be set because there's already precedents, but they could be used as a case in precedence if someone else had to argue how the judge wasn't actually unbiased and everything. I think that's interesting because they're making some really good points, like Divine Virtuous Woman said too.
All right, talk about his due process rights to cross-examination, to see, hear, and be present for everything that's important. The Star Chamber meeting between those three undermine the public's faith and integrity in the justice system. Like, he's laying it on thick. He's like, he's basically saying, whoever decides this motion, are you guys going to side with them? Are you all part of the same smart tech here? You're all on the same team? You don't want to be with those guys. Anti-justice, people that do things in the hidden shadows away from the camera. The injustice must end today, he says. Judge Glanville and the indecorous Star Chamber, again, he's really stretching his vocabulary. Ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for granting of this motion to recuse under our Code of Judicial Conduct and a constitutional violation of due process.
Okay, if you watched along with me, or if you went to Caleb Bumpus's YouTube video yourself, or if you watch the lawyer, when he reviewed the transcripts and everything, they were talking about how, in fact, I believe it was them, the father son right here. They were talking about how the prosecutors were essentially providing counsel to Kayla, and I think also to maybe Woody, in the way that they were answering his questions or something. Woody answering his questions or something, but that seems like a strong point right there too. I need Steele to be my lawyer if I ever need one. He is top notch, earning every penny. Yes, we need a Steele. Yes.
Yeah, they're continuing to build their case of harm because they anticipate that some judge is going to say, well, this may have been wrong, but it's harmless error. And that's what they're anticipating. So that's what they're creating here, is creating as much harm. So now we've got a Brady violation. Now we've got a due process violation, and he's going to keep going.
Yeah, this is anything but harmless is what they're trying to say.
Right.
Not only is there an appearance of partiality, but there's actual bias of Glanville. It's been embroiled in this trial. We've watched some of those clips together. Steele has brought it up multiple times. And this is what we always say. This is why you protect the record. This is why every time a problem comes up, Steele goes up there, he makes his record, he makes his argument. When he loses, he goes back and sits down. But guess what? When something huge happens, like this ex parte meeting, now you have record evidence of all the problems, all the reasons you think Glanville is biased, all the issues that have popped up in this case that you can stack on top of each other and then create this mountain that he's presenting in this motion.
We were all guessing that too, or had the gut that like a gut feeling that he is he and his co-chair, the other defendants' attorneys were like, we're just gonna get this on record. We're just gonna get this on record. This is not ethical. This is not right. Here's the rule, the Georgia rule, and everything.
Glanville had an ethical duty to recuse himself, and he didn't do that. He leaned on Mr. Copeland to testify. He coached Attorney Bumpus on how to sell it to Mr. Copeland. He coached Mr. Copeland on how to deliver his testimony and promised Mr. Copeland that he would not be prosecuted even for perjured testimony unless he told a bold-faced whopper lie. These public officials heard and failed to reveal to Mr. Copeland that Mr. Copeland confessed to committing every indicted offense in this case. And again, whether or not you think Copeland's telling the truth or whether he would have gotten picked apart at another time, I get all that, and that's all fine and good. But that's for the prosecution to do. If the prosecution wants to prove how that's not true, that's fine. The defense is entitled to present that to a jury, and the jury will make the call. And maybe the jury would never have believed Copeland, but that's not the question. That's not the point. All right. We've got a lot of law students in here. Rain said she's studying for the MPRE and following along with our coverage. That's cool. Well, this is a case where you can learn what not to do ethically, potentially, as a lawyer. All right, what else we got? Glanville should not be rewarded with the opportunity to continue to provide over this case. These three lawyers must be recused and removed from the case. It's important to note Glanville originally denied Mr. Williams' request for access to the ex parte transcript. That's true. We can't forget the fact that his first response in action was to hide it and deny access to it and call it privileged. And then he literally changed course immediately when he realized, of course, it's not privileged.
Right. He was like, nope. He came back with a different tune. I have to keep remembering that this is not just for this motion is not just for Glanville. This motion is for, like they said, the two lead prosecutors as well on this trial. So, interesting.
Which is exactly what Steele said the day the ex parte hearing happened. Fortunately, mounting pressure related to Glanville's gross misconduct, violation of his oath, ethical violations, potential criminal conduct by Love and Hilton, and Judge Glanville worked to effect change. On June 17th, Glanville denied undersigned counsel's motion to recuse and went forward in the case. Then he denied Weinstein's motion to recuse and then continued to unlawfully preside over the case. He must be removed as he has proven to have actual bias as well as the appearance of bias. Undersigned counsel has never been afforded the questions that Lawyer Hilton and Lawyer Love created and gave to Mr. Copeland. Do you think they're entitled to that? I don't think they're entitled to that.
It depends. If they gave it to the judge, they might be entitled to it. Remember, we saw it in the transcript, and it was like kind of came out of nowhere because we didn't really see where did the judge know that Ms. Hilton had questions that she had already written out for Copeland. And if Copeland used that to prepare for his testimony, they are entitled to it as well. So if they gave him the Copeland to prepare for his testimony, the defense is entitled to it because they're entitled to anything that Copeland did or saw in preparation for his testimony.
Great answer from the dad, because I sure needed to know as well.
Glanville's been made aware of these questions and encouraged Attorney Bumpus and Copeland to review and understand these questions. The questions must be asked why Mr. Glanville has ex parte access to Lawyer Hilton or Lawyer Love's questions for a witness. The conduct is beyond repair. Lottie asked, Steele added Glanville, Love, and Hilton to his witness list. Why not Melnick and Bumpus? At first glance, he really wants to prove that these three need to be witnesses. And they're now on the witness list, which proves he may call them. Bumpus and Melnick, he could still add later if he wants to. He can still call them. They're not prosecuting the case. They're not presiding as a judge over the case. So it's just different to call them versus these three. It's very unusual to call the judge and prosecutors on your case.
Right. The odds are that Bumpus Melnick would cooperate. And so they're not really worried about subpoenaing them and having their testimony. They don't think they're going to get a fight out of Bumpus and Melnick. They know they're going to get a fight from the judge and the prosecutors.
Yep. Ms. K, it's a good question.
Now, I'm going to say this. Now, y'all, this is so outside looking in. He probably wouldn't steal. Young Thug's attorney probably would not get a fight out of Melnick, which is the original attorney Woody in the sense of this whole pleading the fifth and everything. But when Kayla Bumpus filled in for Melnick, there's a lot she obviously takes Woody's side on and she takes Melnick's side on, but she does seem to be soft towards Love and Hilton. Is that the other one? Love and Hilton. So I don't know. Like he might just want to be ready just in case, because Kayla's kind of like, they're not that bad of people. And it's like, it's cool. They're not that bad of people. Are they? I don't know. If y'all watch her live, you can kind of see. And I feel like maybe, and also this could be the thing too. People might have been attacking them outside of how they handled the law. And I could see as a Black woman looking at other two Black women that were being attacked. Maybe that's where she was coming from. I don't know, but she did seem hesitant on some criticism with them, if that makes sense. So that's just kind of how I was just watching her. I was watching her interact with Woody, watching how she described Love and everything. So I don't know. I'm curious about how that would go forward if she had to become a witness.
We just not one we can know. Azam, long time. We usually read them in chunks. Yes, hit the like button, please, if you guys haven't already. I always forget to say that in these for some reason. I don't know if it's having somebody else on or what, but hit the like button and subscribe to the page if you guys haven't already. Okay. So the three public officials, as we'll call them, did not give a hint that they were meeting ex parte with witness Copeland or at any point. Undersigned counsel had no idea that this was happening and that these ethical rules were being broken behind closed doors. They had a duty to immediately announce this to Mr. Williams, and they didn't. And he repeats all the reasons why. Glanville, Lawyer Love, and Hilton, acting in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting.
Another way of saying the same thing, acting in concert. Like I said, he must go to a thesaurus and find how many ways can I say the three of them were acting together. Now he's using the word concert.
And again, all of this is really interesting context before we read the state's response, because he says they're trying to normalize this behavior and act like it was no big deal. Just wait till we read their motion. This misconduct undermines the trust in judges, and prosecutors cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and criminal justice system at large. Georgia courts have always safeguarded and separated prosecutors and their duties from judges and their duties. That's important. I've had a lot of people ask me on this show, and if you want to just give your comment, Dad, people always say, how is it fair? Why is it fair that the government pays prosecutors, judges, and public defenders? How is that fair to a criminal defendant? How are they all not just always in cahoots together?
Well, they're not responsible for each other's salaries. That's the one thing. A judge's salary is set by the legislature, and it comes out of the general budget. A prosecutor's salary, again, is set by the state attorney in that particular district. The state attorney's salary is set, then he determines what the assistants are going to get. Same thing with the public defender. That is set by statute, and he decides what his assistants are going to get. So it comes out of the general fund, but no one controls what the other one is going to make, how much they're going to make, or whether they're going to get paid or not. So,
additionally speaking, the government that pays them is individually interested in what each produces. So the government is interested in fair and just prosecutors, in fair and impartial judges, and public defenders that will defend the rights of the citizens and taxpayers in that jurisdiction. So it's not like the government wants everybody to go to prison or the government wants everybody to go to jail. They want fair and just prosecutions, defenses, and judges. So each one of them has their role to play, and the government is interested in all of their roles, and so are the citizens that pay the tax dollars that pay these people, right? So we have to remember that as well. We say the government, we say the state, they represent the people of the state of whatever, but in reality, each has their own function.
Well, the theory is the prosecutors are ministers of justice. The theory is that prosecutors are not supposed to prosecute innocent people. So, they're the ones that make the decision who gets prosecuted or not. So they've got the greater responsibility. And that's the theory.
As stated in here, Mr. Williams intends to call Judge Glanville as a witness at trial, as well as at this recusal motions evidentiary hearing based upon his improper conduct and the need to make a further record to protect Mr. Williams' constitutional rights. Specifically, there appear to be communications not captured on the transcript of June 10th ex parte meeting. Lawyers Love and Hilton and Glanville. Examinations are needed to complete this record. Oof. Judge Glanville is a necessary witness in Mr. By the way, Bumpus saying, and even Copeland saying, nothing super important happened off the record is not necessarily their call to make, right? If you're the defense attorneys, you'll say, well, I'm going to have to decide at this point what's important and what's not. So I'm going to have to ask everybody what was said. I'm going to have to, take their deposition or question them at trial or some kind of hearing. And I'll decide if it's Brady or if it's important to my client because you don't represent my client. And that's also fair as well. So
I'm glad he said that because I was watching attorney Kayla Bumpus when she said nothing was essential that was left off the transcript, in her opinion, I'm sure. And I was like, well, he still left it off the transcript, though. He meaning the judge, and between probably him and let me put my banner up because I'm over here guessing. I ain't saying nothing is fact, but they left it off the transcript though. So I'm like, attorney, still let me see and determine if it's not important to my client. Like, it's still, why is it off the transcript? If it's, I need to see it.
something that could be argued by Steele. Glanville is a necessary witness in Mr. Williams' trial, and his name will be used when undersigned counsel cross-examines Mr. Copeland when asking questions. Whether Judge Glanville pressured Mr. Copeland to testify, whether Mr. Copeland realized Glanville was allowing wrong propositions of law to be explained to him, and the fact that Judge Glanville condoned Mr. Copeland's lying under oath unless it was a bold-faced whopper. He likes that quote. And this is also another important part. Like, people sometimes are like, our lawyers are being a little rude or presumptuous to tell a judge what to do. Lawyers instruct judges all the time or argue what they think the law is, how they think it should go, what they think the jury instructions are. Judges are supposed to figure out what lawyers write, read the research, do their own research, and make a call. It's not disrespectful for a lawyer to disagree with a judge. No. So the fact that they think Glanville described the law wrong to Copeland, if this was an open court, they would have had their opportunity to make their argument on the record, do their research, and have the judge make a call, but they weren't afforded that opportunity because it was an ex parte hearing. Grounds for recusal are contained in OCGA 1518, as well as Georgia Code of Judicial Conduct. The judge should be disqualified for bias against a party if such bias stems from an extrajudicial source and results in an opinion on the merits on some basis other than what the judge learned from his participation in the case. The alleged bias of the judge must be of such a nature and intensity to prevent Mr. William from obtaining a trial influenced by the judge's bias. Do you think we've gotten there in this case with what you've seen?
I think we have, but I want to wait to balance my argument when we read the prosecution's response.
Okay.
But yes, I think we have. Absolutely.
In the case at bar, it's impossible to honestly find that Judge Glanville is an impartial, fair jurist. Recusal is mandated. The judge must avoid all impropriety as well as the appearance of impropriety. Judges shall disqualify themselves in proceedings in which their impartiality might reasonably be questioned. The fact that Judge Glanville's impartiality might reasonably be questioned is grounds to mandate that he is removed from this case. Talk about the rule to disqualify the judge. Similar arguments that they've made before. They should disclose on the record if something like this happens. Impartiality might reasonably be questioned means a reasonable perception of lack of impartiality by the judge held by a fair-minded and impartial person based on objective fact or reasonable inference. Recusal on this ground requires a rational basis for such questioning, not an arbitrary basis, even though no actual impropriety on the part of the judge has been shown. And he's citing a case there. As seen in Exhibit A, Judge Glanville's impartiality under this definition has been satisfied. Further, the Code of Judicial Conduct mandates that the judge step down from presiding over a case where the judge is likely to be a real and essential witness and where this is not substantially the same testimony available from another witness. So that's interesting. Do you think that Glanville could argue it's substantially the same as what the other people in the room could testify to?
No, because he's a judge. And I think his position is different.
Yeah.
And if you don't recuse him, the other people are going to testify about what happened in his courtroom, in his hearing room, and he's going to be sitting up there on the bench. You just can't have it both ways. Either he's going to testify as a witness and he's got to be off, because you just can't say, yeah, Judge Glanville was there. Yeah, he allowed this to go on. And then he's going to be sitting up on the bench looking at the jury smiling going, You just can't let that happen.
And then this last part, Glanville's out, except when he's called to testify, questioning his misconduct and bias before the jury. He can come back for that. That's what Steele says. Then he repeats bias and prejudgment, prejudice against Mr. Williams. He asked this honorable court to have a hearing The judge is so involved in the controversy that his objectivity can be reasonably questioned, and he must be removed. The facts are so clear that Glanville, in order to shield himself and his co-prosecutors, so again, he's calling all three of them prosecutors together from
Right.
the
In other words, he found another way to say it.
Denied Mr. Williams' June 17, 2024 motion to recuse without a hearing, without providing a transcript, and without permitting another court to hear the motion to recuse dated Monday, June 17, 2024. This demonstrates that Judge Glanville is involved in this controversy and cannot be deemed fair and impartial. I definitely think he is so inextricably intertwined at this point that something needs to change. And I don't really think that he could stay on this case for a number of reasons, which we'll talk about later. Bias against a defendant, it feels like he's more biased against Mr. Steele potentially than Mr. Williams.
I do think that they are inextricably intertwined as well. Being the judge, the prosecution, now the judge may have more of a point to prove. I also think he probably really don't like some Attorney Steele. I agree with that. So yeah, something's going to have to change. I wonder if there's going to be some compromise, because now the perfect world would be that they change out. Well, I don't know if that's perfect world, but one of the things would be they change out Judge Glanville for the rest of the case. Obviously the attorneys want Glanville and prosecution changed out, so that's an option. Maybe I don't know if they could just change out prosecution, if that would help enough, because if there is still a jury and everything, so I don't know. But yeah, all three of them, too much intertwining going on.
The rules of disqualification are in play. Glanville is required to avoid not just impropriety, but the appearance of impropriety in his actions. This is because public confidence in and respect for the judiciary and our courts must be maintained. As shown in Exhibit A, attached here too, the shocking conduct of Lawyer Love, Hilton, and Glanville proves that bias and prejudice have been shown. It has been held to be elementary that a judge must be disqualified when he's going to be a witness in the same proceeding. In the case, Justice Glanville has taken on the prosecutorial role against Mr. Williams and must be recused. Circumstances illustrate perfectly the inescapable conclusion that Glanville is partial to the prosecution, biased against Mr. Williams. Glanville attempted to cover up the meeting. Okay, we've read that a couple times. All the actions taken by Glanville after this ripe and valid recusal motions were filed are void. Glanville has caused Mr. Williams immeasurable suffering and prejudice based upon his, Love, and Hilton's denial of Mr. Williams' statutory and constitutional rights stated herein. Mr. Williams must be granted a reasonable bond. Here we go. This is an additional argument here. Mr. Williams' statutory right to a speedy trial has been totally upended by Love and Hilton and Glanville, and Williams must be cleared of all baseless charges. So interesting to call the charges baseless. This doesn't prove that they're baseless, but what do you think of that comment?
Well, I think he's if you notice, it's not the theme of the motion. He stuck it in here, but he hasn't repeatedly asked for the charges to be dismissed. This is a step-by-step process. So first you get him recused, and then the trial has to be continued. There has to be a mistrial. After the mistrial is declared, then you ask for a bond, because he shouldn't be held in jail. It's not his fault that things are still dragging on like this.
You better believe they're going to make a double jeopardy argument.
Right. And then when the mistrial is granted, they will say, well, the mistrial, my client was put in jeopardy. There was evidence presented against my client. He was not found guilty. And therefore, under the constitutional double jeopardy rules, the case should be dismissed because it's not his fault. It's prosecutorial misconduct that caused the mistrial. And so this sentence basically is foretelling the future and what the next couple of motions are going to be.
Oh, he didn't. 4150, isn't that military term? He said they worked in lockstep to ensure Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal due process, all of that have all been crushed. This trial is a farce. Ooh. I was trying to get to the part where he read about a mistrial, and I don't know if I scroll up and see it. Okay, yeah. He's introducing how this will be a mistrial if we continue keeping Glanville on here. Okay, but yeah, that lockstep.
when again, we should take this one step at a time because that's the way the courts want you to do it.
Mm-hmm. Mm-hmm. Morgan asked why it's called a star chamber meeting.
Many of you maybe
Really think they don't know what's going on.
I skipped that part because I read the definition of a star chamber meeting. Okay, keep going.
It sucks. I mean, at this point, they're just like, hey, guys, chill for a month in the middle of this trial.
Or a couple months, go to work for 2 months, then tell your boss you're going to be gone for another couple months. Or
it's hard enough to remember the evidence at the beginning of a trial. Imagine evidence from a year ago.
I know this is terrible. It's terrible for everybody. I mean, it's not just terrible for one side, but you think there's no person involved in this trial that isn't suffering because of this.
So Nikki said, does anyone know if a witness is offered immunity, are they required to accept it? So they can't plead the fifth anymore because it's no longer potentially incriminated if they've been granted immunity. That's the big connection here. All right. Do you think the DA will be disqualified, or you want to wait until we read their motion before we talk about that?
Well, I want to read their motion, yeah.
Okay.
Let's
All right, let's keep going here. Attached joint affidavit A supports this recusal motion. Glanville's extrajudicial misconduct cannot be ignored. Glanville, Love, and Hilton have worked in lockstep to ensure that Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal, due process, right to be present at all critical stages of his trial under the federal constitution, as well as Article 1, Section 1, Paragraph 12 of the Georgia Constitution, right to cross-examine, right to present a defense, right to effective assistive counsel, right to assist counsel have all been crushed. This trial is a farce. So he basically hits every single thing that's literally the kitchen sink. Denying this motion to recuse and permitting Judge Glanville to continue as a judge perpetuates injustice. This case can never return to constitutional normalcy based solely upon the improper misconduct of Love, Hilton, and Glanville. Any tragic conviction and sentence in this case will likely be reversed. And again, that's more money, more time, more resources. Judge Glanville has made himself a necessary witness as has lawyer Love and Hilton. Should Judge Glanville not recuse, Mr. Williams would be prevented from exercising his constitutional right to call witnesses, as Mr. Williams needs to show the jury how and why Love, Hilton, and Glanville were not just doing their jobs as public officials, but were teaming up with a united front to convict Mr. Williams.
Again, another way of saying it. I mean, I say he just says it 50 different ways in this motion.
Once armed with this evidence, the jurors can then properly determine what, if any, of the testimony and these facts will bear on their verdicts. Judge Glanville must be removed. So I do agree. Like, this stuff needs to go in front of the jury, and the jury's going to determine how serious it is. All right, this is more repetition about the initial motion to recuse. Before the jury, Judge Glanville will be spoken about in terms of work as a member of the prosecution team. Judge Glanville will be called as a witness by Mr. Williams. So he's saying he's going to argue that to the jury. Do you think that's... Let's say Judge Glanville stays on. Can the defense still make that argument?
Yes, I mean, that's why he can't stay on. If they're allowed to make the argument, which is reasonable, he can't stay on because how can the jury possibly be fair when they're told this judge who they respect and who's making all the rulings is also part of the prosecution team? How can you get a fair trial?
And talk about how they could question Copeland about this. At the very least, they can cross-examine Copeland and ask him stuff about Judge Glanville, right?
Oh, sure. Were you intimidated? How many people were in the room? What was going on? Were you in handcuffs? These are all things that have been raised in other contexts, and just to show what the room was like. And Attorney Bumpus, she'll be testifying about what Glanville said and did in that room. So I definitely think that there's just no way to proceed and cross-examine Copeland with Glanville being there in the room and being the judge.
Reese's mom says, I could see jury nullification in this trial. I'd be a pretty angry juror at this point. So the jurors don't know about 90% of this, which is so interesting. But if Glanville stays on the case, I think at least some of this is going to come before the jury, and they're going to figure out some of the problems and shenanigans that are going on. And that's the other thing. This trial almost can't continue, which is kind of sad. But to bring all this up, and then the jury's thinking, is that why we've been out for a month? Because the defense thinks the judge did something wrong, and the prosecutors did something wrong in this secret meeting, and these arguments start to be made. It just becomes so messy, and there's a reason these types of arguments don't usually come out of trial.
Right, and if you're a juror, you're going to think the defense is all full of hooey if the judge is still sitting up there, this Glanville, the guy they say has done all these wrong things, yet he's still sitting up there as the judge. Boy, obviously the defense is just, full of caca.
Glanville has given lawyer Love, Hilton, and Bumpus and witness Copeland legal advice.
Oh,
Mr. Williams, jurors need to understand who has been orchestrating this kangaroo court.
let's stop for a second.
Yeah.
Notice how he talks about Bumpus. This jumped out at me. These aren't mistakes. It's lawyer Love, lawyer Hilton, and honorable attorney Bumpus.
Oh, interesting. Interesting. Because y'all know Kayla Bumpus filled in to represent Lil Woody at the ex parte. I keep wanting to say like ex parte meeting. I don't know what to say. Or is it just leave it and just say ex parte? But yes, because Kayla was not involved with the prosecution. She was just trying to do the best to represent her client. And she was a fill-in, a stand-in for Melnick, who was Woody's actual attorney, for him to plead the fifth, I believe.
Where has he ever said that about anybody else in this motion? It was not an accident.
Yeah, and I mean, he's making it very clear, almost like a threat to the judge. We're going to make these arguments, whether you like it or not. As attested to in Exhibit A, Judge Glanville received extrajudicial information and also gave opinions and legal advice that included, but are not limited to, that Mr. Copeland went to prison for crimes committed on behalf of YSL, a contested fact in this trial. Mr. Williams and their other co-indictees know Mr. Copeland and his criminal conduct that is not known to the judge, to Judge Glanville or the prosecutors. 3, Mr. Copeland will be cross-examined on his other crimes evidence because Mr. Williams and the co-indictees have far greater knowledge of Mr. Copeland and his background than others. And 4, the like, by embracing this extrajudicial information, Judge Glanville believes that Mr. Williams is involved in criminal activity with Mr. Copeland, and Judge Glanville expressed that fact to Copeland in order to push Copeland to testify against Mr. Williams. This is a pretty good argument. Don't you think? I mean, it's a pretty good argument that the judge feels like there's a bunch of criminals sitting in the courtroom.
Oh, yeah. I mean, let's face it, he probably did before he met Copeland. But, you know, after talking to Copeland, they have some concrete evidence now that he does know. So, yeah, it's all going into what's in Glanville's head. Can they get into his head? And is there enough there to get him off the case? And I think, again, I agree that there is, but I've been wrong before.
This is I sometimes I fail to understand the timeline on this too, y'all. So I am going to reread this part because for some reason, because it's happening where it's happening, I'm just like, oh, he was in jail for like, I don't know, a month, couple weeks. But Woody, not Woody, sorry, Young Thug it says Hilton Love. Instead, Judge Glanville, lawyer Love, and lawyer Hilton have manufactured an unfair, unconstitutional, broken trial and has caused Mr. Williams, which would be Young Thug, severe prejudice by incarceration for over 2 years without bond, and a laughable trial that has lasted entirely too long with the games played by lawyer Love, lawyer Hilton, and Judge Glanville. Judge Glanville must be removed. Does this say instanter? I can't see the word, but dang, it has been a long time.
These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate Judge Glanville be removed. Moreover, Glanville's derogatory and prejudicial statements and demeanor must be considered by this honorable court as attached to Exhibit A. Again, we saw a lot of videos of those between the exchanges between Glanville and Steele. Glanville had an ethical duty to disqualify himself in this matter as he clearly has a personal bias and prejudice concerning Mr. Williams and the other co-indictees. Mr. Williams' counsel and other defense lawyers in this case, Judge Glanville has violated his oath by not voluntarily disqualifying himself to avoid this impropriety and appearance of impropriety. Instead, Glanville, lawyer Love, and lawyer Hilton have manufactured an unfair, unconstitutional, broken trial and has caused Mr. Williams severe prejudice by incarceration for over 2 years without bond and a laughable trial that has lasted entirely too long with the games played by lawyer Love, Hilton, Judge Glanville. Judge Glanville must be removed. The instances discussed herein, as well as Exhibit A, represent more than mere friction between zealous counsel and a diligent jurist, because he knows that's what Glanville has said in the past, and he wants to take that type of a argument or statement away from the presiding judge. Right?
Yes. I'm sorry.
I didn't know if you were going to say anything about that. Okay.
No. I mean, I have. So that in itself is not enough. But he has to rely on this ex parte. This other stuff is good. It's nice window dressing, but it's not going to make a difference.
Yeah. To me, that's why you build all that up, because individually that stuff is not enough. Like we've been talking about, as annoying as it may be, as frustrating as it may be, but it's not enough on its own.
Right.
He should be disqualified from any contact with this case moving forward based on his prejudice, as cited above. The ex parte is the big thing, obviously. As cited above, ex parte communications are presumptively harmful error. State has the burden of rebutting this. They'll become evidence before the jury. In order to attempt to explain this injustice to the trier of fact, Judge Glanville, Love, Hilton will become witnesses. Mr. Williams is entitled to know these communications between Glanville, Love, Hilton, and Mr. Copeland. So I have a question for you. Do you think if this gets mistried and they try it again, and the state in that case, let's say that this state gets booted off the case, and the new state attorney wants to call Copeland, do you think it's appropriate for the defense to call Love, Hilton, and Glanville to talk about how Copeland in another proceeding was not going to testify, but now he's here testifying? Does this have anything to do with judges and prosecutors in other jurisdictions forcing him to testify?
I think what they'll do is fashion the question so it does not refer to a prior trial. What they'll do is they'll fashion.
You think they'll be able to bring this in?
Yes, they'll be able to bring this in. Hey, you didn't want to testify, did you? You were forced to testify, weren't you? In fact, when they were talking to you about testifying, you say that you're nothing but a liar. They can ask all that. They just can't say, well, weren't you in a trial before where you were a witness? That'll be excluded. But how he got here and why he's testifying, that can all come in, yes.
So my specific question is, do you think they would call Glanville, Love, and Hilton?
I think they'll try, yeah.
I know, but I think based on what you're saying, another judge may find that it's not relevant to call them three, but I definitely think the defense can get into that subject matter. So it kind of leaves an open question. Will Glanville, Hilton, and Love be a witness in a future trial where they're not the judges and the prosecutors?
Well, another question too is it also depends on how Copeland answers the questions.
Right.
If Copeland answers the questions that lays out exactly what the defense wants, and there's no reason to call Glanville or the prosecutors, then that's a different situation. If Copeland lies about what happened in that hearing or doesn't remember, which is a very common Copeland answer, then yes, there's going to be an issue, and they may be able to call them for witnesses.
Oh gosh, that would be crazy. Glanville, Hilton, and Love have stolen forever Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutory fair manner. I don't disagree. This is almost getting to the point where this doesn't even look like a jury trial. Judge Glanville, Hilton, and Love have goaded Mr. Williams into moving for mistrials. All of the conduct in all proceedings after the Honorable Douglas Weinstein's, as well as undersigned counsels, filed their motion to recuse, and affidavits are deemed invalid and have no effect. Mr. Williams' constitutional and statutory right to a speedy trial has been stomped on by Glanville, as well as Mr. Williams' right to due process, fair tribunal, et cetera, all of the things that have been stepped on before. He talks about his affidavit, how it sets out everything they need for this motion to talk about how he's violated his oath of office. As explained above, ex parte communications. Ali said he thinks the judge or the jury has already heard about this. I don't think they've heard about this specifically, but I could be wrong. As explained above, ex parte communications are presumed to be error. And once Mr. Williams has shown that Judge Glanville received ex parte communications, there is a presumption of harm that can only be overcome by affirmatively showing that Glanville did not consider these communications. Their conduct is reprehensible. Glanville has never affirmatively stated that he has not considered these ex parte communications.
Let's stop there. That's very important. The reason they put that in there is because if you remember in their prior case law that they cited, they said that it can be overcome if the judge says that whatever happened in those ex parte communications, I didn't take into consideration, I don't even remember what was said, and it has no effect on my decisions. By the judge saying that, he can minimize the impact of the prejudice or the harm from the ex parte communications. And this is very important that Glanville has never said this. And they're going to.
I love how they're laying it out. They laid out the case where, if he hadn't said that, it could have, helped the judge and helped this not be seen as using something that could be used against his client because the judge is saying he wouldn't even consider it. But they laid out the case first that would reference how they could overcome that. Then they lay out that Judge Glanville did not do that himself, though. Bonnie, to try to get you on the same page, Attorney Steele, who is writing this document right now, represents Young Thug. He is laying out his case on why The ex parte meeting and other actions by Judge Glanville and the prosecution should have Judge Glanville removed, but the judge that was chosen to look over this apparently works for Judge Glanville. I don't know why the system would have someone that works for Judge Glanville be able to make this decision. But the way Shan was saying it too, if it gets denied, when it probably gets denied, they will appeal to the Georgia Supreme Court. So then it will definitely be outside of Fulton County. But I don't know why they just would have started by just not having someone within his own county that works for him even be the one that can decide if he needs to be off the case or not. I don't know why they do that.
Beat him over the head with the fact that he's never said this.
Yeah, it's interesting too. Like, he could have said it, I guess. It's just kind of weird in these circumstances. Like, it's all about a witness's decision. It's kind of weird that the judge was involved at all, to be honest with you. Like, outside of holding him in contempt, what does the judge have to do with any of this?
Right.
Lawyer Hilton and Love have never uttered a syllable denouncing these ex parte communications. Instead, they promote the propriety of the ex parte communications. The state cannot refute this presumption of harm, even though that's how the process works and they have to. Supposed public officials, again, he throws that slight out there. Glanville had a duty to recuse himself, which we've heard about a lot. Law also requires this honorable court to recuse. The public must believe in the absolute integrity and impartiality of judges.
Now, you know, here we're talking about the current judge. We're not talking about Glanville anymore.
I'm so glad the father pointed that out, because I was like, okay, is this all in the same document? Because I felt like it was, because he started out the document by saying we need the judge that's supposed to decide this to recuse herself. Maybe there's a separate motion too, but I could have sworn it was referenced in this document, so I'm glad it's coming back up now. Or maybe this is the first time it was referenced in here. Maybe it was me reading the article and I'm thinking I also saw it in this document already. So I'll let him continue, because that might have been when I read the article and I'm mixing up the article with this document now.
Oh, this is
the judge that's
so when he says this, now we're talking about Krause.
Right, we're talking about Krause here.
So Glanville, Reese's mom said, if Glanville is not recused, how can they possibly go forward with a fair trial? I mean, I just don't see how it happens.
I don't either.
Honestly, I don't see how it happens. Didi, can they argue the state immunity won't protect Woody from federal crimes?
Yes.
So I don't know if that's something that the defense is necessarily going to argue, but that's one of the improper instructions of law that happened in the ex parte communication. Do you want to talk a little bit about this?
Well, here is, and we'll talk more about this when in the state's argument when they do their response. But the key is, it is not Steele or Williams' rights that were violated by the Fifth Amendment issue. That's Woody. Williams was violated because he wasn't told about the Woody issues, and he couldn't use it for Brady and for cross-examination. But the immunity issue is strictly a Woody issue. And so if this issue, the argument is Woody's argument, not Williams, that the Fifth Amendment doesn't cover, at least the immunity that he got in state court doesn't cover his federal crimes. Woody could argue that. And like you just said, Peter, this is one of the mistakes that were made, and we pointed this out when we went through the transcript, is these are the mistakes they made when they tried to give him legal advice about his immunity. They were wrong about the federal crimes. So yes, the answer is the immunity will not protect him from federal crimes.
The Supreme Court of Georgia observed that our JQC has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit.
Okay, if I could interrupt you here for a second. I read Smith versus Guest Pond Club because I was curious. That's the case they cite for this proposition. And it was a really interesting case. And if you got just a minute, I'll tell you about it. Is that what it was in a county where I guess the county is not big enough to have full-time judges. So there were two part-time judges. They were lawyers one day, or they were judges another day when they needed judges. Well, one was the lawyer in the case and the other was the judge in the case. And what happens is they're the only two juvenile court judges in this county. So they confer on cases all the time. And when they're elevated to superior court, before they can go to superior court, the other judge has to okay it. So one judge who was sitting in this case had to be okayed to be the judge in that case, where the other party in the case was represented by the other judge in his capacity as a private lawyer. I mean, they were so intertwined in this small county that the judge said you had to find somebody else outside this county to hear this motion.
Shout out to the dad again for reviewing that case, because that is very interesting. That is different, because if the way they pull the statement, you would think that that's just in general, but for it to be, because there's only two people and they just swapping roles all the time, that's why the ruling was like, no, you can't be in the same circuit. So I wonder if they might cite other cases too, not just that one. But that's a very interesting, unique type of case right there, where one day they're the lawyer, the other one, and the other one's the judge, and they switch off and they make the decision about the other person. Like that's interesting.
It was a very interesting set of facts.
All right. I saw in the chat as well that some people said that our mics are not exactly the same. So to turn yours down or turn mine up. So I tried to adjust them a little bit. Hopefully that helps. No, you're fine. Just, you don't have to lean in. No, yours.
Okay.
They were saying yours was loud. So we're good. We're good.
Oh, okay.
Furthermore, this honorable court has received a $2,000 donation in its re-election campaign in April during the pendency of the trial. Glanville giving this contribution for re-election could be deemed an exceptionally large campaign contribution, and thus is another reason this honorable court must recuse from presiding over this case. And that's basically the end. Okay. So then there's, 200 pages of attachments that we're not going to go through, but it's affidavits. It's the transcript of the ex parte hearing. It's everything that they have to support this motion for recusal. So I'm going to throw this question up for you, Dad. Rosie said, how is what the state is doing by gifting immunity, not witness tampering / coercion? You answer that while I bring up the state's motion here.
Well, it is because they are the government and they are the Supremes. They're allowed to give immunity to witnesses so that they can get to the truth. That's the theory behind immunity. So if someone's willing to testify, but they don't want to testify because they're worried about getting arrested for something, and the government believes their testimony is important, they can give them immunity so that they give them immunity so they can catch the bigger guys. And you can see where in some cases it's necessary to give immunity to the little guys in order to catch the big guys. And the government has that discretion to do that. Otherwise, a lot of crime would go unpunished if little guys couldn't testify against the big guys. That's the theory.
And there are some people that are like, some accountant whose family gets threatened and he does some illegal acts for, the cartel or something. It's like, you want that guy to testify against the cartel. You can understand more how he got himself in this situation, whatever it may be. You've seen it in movies. That's
okay. The document they have open now, and I'm sure this is most likely the last document, is where the state responds to Attorney Steele's motion that he filed that they just finished reading. So now this is the state responding, and the state, I'm wondering, would it be Love and Hilton, the prosecution that is against, asking for them to be removed from the case. So, okay. So they're about to get into that now.
Stuff happens in real life sometimes too, where people get into bad situations. They're granted immunity so they can testify to help get the real bad guys. All right. State's response to defendant's motion to recuse Chief Judge Glanville in the trial of the above style case. Midway through this now months-long trial, defendant Jeffrey Williams and defendant Kendrick have each filed motion to recuse. The state recognizes Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to this honorable court. And of course, because they say it's properly assigned to this honorable court, but the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the three requisite determinations, whether the motion was timely, whether any affidavit made in support of the motion is legally sufficient, and whether if some or all of the facts set forth in the affidavit are true, recusal is authorized. Accordingly, it falls to this honorable court to make those determinations. As set forth below, though defendant's motion and supplement are in part timely, and the affidavits in support of defendant's motion and supplement are in part legally sufficient, none of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. Defendant's motion and supplement should therefore both be denied. That feels like insanity to me. to say that, nope, they don't quite rise to the level of recusal, even if everything they said was true. I mean, that's crazy. To say that what they said is not true is one thing. But to say, even if all that is true, the judge shouldn't recuse himself. Oof. I'd hate to see.
Ooh, that is a that does seem like a weaker argument to be like, let's assume even if all that's true, that's not enough. So I wonder, are they going to actually expand on how that's not enough? But to even, because again, still you accuse them of working together and they're not supposed to work together. So you shouldn't really say, even if all that's true type argument. You're not supposed to be working. You're not supposed to be cohorts. You're not supposed to be bad actors. You're not supposed to be on the team. You're not supposed to be advising. The prosecution shouldn't be advising the defense counsel. Like, what do you mean? Even if all that's true, that's not enough. Wow, I thought at least the basis was you're supposed to deny, and they just said it still wouldn't be enough. Ooh. 41 said he should recuse himself, though, is giving obsessed. Was probably pride on both sides. Pride that he's in this high visibility case, international, as they're saying, because I didn't even think about other countries watching it. High visibility case, and then now he was challenged by Steele, held him in contempt, but then had to come back and say, okay, here's part of the transcript. Okay, we're going to take a pause, blah, blah, blah. So, yeah, he's going to have to be obviously removed. He would not obviously, he already said he's not removing himself. But yeah, that pride is crazy.
What she thinks does warrant a recusal. The actual
they have made, what they've done as we go through this, they've backtracked a little bit and they've made the best argument they can because their other arguments have just turned into mush.
Procedural.
Yes, their procedural arguments and their factual arguments have turned into mush. As we go through, and I'll say it now because we can look through as we go through. If you remember the emergency nature of this ex parte hearing, well, when you read through this, I want you to look for where they allege there was an emergency and what the facts of the emergency were, because I don't think you're going to find it in this motion. I think they totally left that out, and I think they were smart to do that. They left out the emergency nature because there was no emergency, and they're honing in on the one aspect that I touched on before, which is the defense doesn't have any rights here. These are Copeland's rights, not the defendant's rights. So we're only protecting Copeland's rights. Therefore, the defendants really are not prejudiced because none of their rights were affected by this ex parte hearing. And it's a pretty good argument. I mean, the fact they've narrowed in on that and forgot about all the garbage they used to talk about, they really did a better job than I thought they were going to do.
Oh my. Okay. The omission of why it was an emergency to even have the ex parte hearing, because I heard the dad say that phrase ex parte hearing, so that's how I'm gonna refer to it. Okay, wow. And I'll just let it keep going because I'll just let it keep going.
All right. On June 6th, the calling of state's witness Kenneth Copeland on June 7th. On June 6th, in response to an inquiry from counsel for the defendants in this case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7th. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland and that Mr. Copeland would be asserting his Fifth Amendment privilege. First off, claiming to represent him, that's not how that works. Like, he represents him. If he calls and says, I represent Kenneth Copeland, he represents him.
And he absolutely does.
Agreement in most situations for criminal cases.
And the record shows he represents him.
If called to testify on June 7th, perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectively by Brian Steele and Max Shart, Melnick copied Brian Steele and Max Shart in his communication with the state regarding Mr. Copeland's intention not to testify. So my other first thought here is, just because the state is calling a witness does not mean they're testifying against the defendants, right? Sometimes state calls friendly witnesses. Sometimes witnesses become friendly, and the state might not know it. And there's nothing wrong with that, right? I mean, there's wrong.
No, well, it's wrong when this. Well, see, it's wrong because the state wants to have all the advantages. the state wants to make sure they control everything. And it bothers the state when they don't control everything. It bothers the state when people aren't scared of them. It bothers the state when people don't do what they say. When you read this motion, you'll see that's what bothers them is, look, they didn't do anything illegal. They didn't do anything wrong. They didn't do anything unethical. It's just they didn't do what we wanted them to do. And Melnick isn't acting like we want Melnick to act. So therefore, we're going to condemn Melnick. But Melnick did everything right, and he didn't do anything wrong in this case. But they're going to jump on him. And you'll see another spot where they jump on him here because, again, they didn't kowtow to the state. And that's what bothers them.
And what I was going to say is it's wrong if a witness is lying and changing their testimony, but it's not wrong if the state thinks that they're testifying against the defense and actually they're not because they're just telling the truth. That happened in the Karen Reed trial, I think, with some of the witnesses. All right. In preparation for trial, Deputy District Attorney Hilton, along with her investigator, had met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state an intention to plead the fifth or to say that he was represented by Mr. Melnick. He doesn't have to tell them that, first off.
No.
He doesn't have to tell them. And he can also change his mind, and he can tell them right before he testifies, actually, I've changed my mind. I'm going to plead the fifth. There's nothing wrong with that. If he thinks he's going to incriminate himself, of course. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June 7th. He also doesn't have to tell her if he has a lawyer or not, but if he does, then she's got to stop. Pursuant to OCGA.
And frankly, you know what? I mean, I don't know if I think they're on notice that Melnick represented Copeland. I think they knew that from prior cases where Melnick was Copeland's lawyer in the prior case. The judge certainly believed that Melnick and Bump.
Wow. Okay, y'all. So I'm taking this as the prosecution's argument is, but we did all that work and then we got there and he pleads the fifth and we had our whole case built, or a critical part of our case built around him being Woody. And then he had no take backsies. Like, and if the attorneys are saying he's not obligated to tell them his plan before he actually sits on that stand, and they basically punished him for not doing what they thought he would do and wanted him to do to help their side of the case. And then to put that in their argument to defend themselves on why this is not enough on the defensive side to have the judge recuse himself and have them off the case. And then that's not even a good argument because these attorneys are saying he didn't have to tell you that though. Who are your strategists?
Represented Copeland. So, you know, they should have made an inquiry. I think they had an ethical duty to inquire Mr. Copeland if he had an attorney, not just be silent about it.
Yeah. Well, they don't want to know, right? They just want to talk to him, force him to say what they want him to say. After receiving what?
They didn't want to know. And again, they're upset because Melnick, the prosecutors are always upset. You know, defense lawyers are never their friends. And they're upset because Copeland met with him and then Copeland said, I'm not talking.
After receiving Melnick's email, the state presented to Chief Judge Glanville, a motion to compel the testimony of Copeland, extending immunity to Copeland for his testimony, and told Copeland and to hold Copeland in contempt should Copeland refuse to testify after being ordered to do so by the court after being granted immunity. Court issued an order granting the state's motion. On June 7th, after the court was called to order, Melnick appeared before the court and informed the court that Copeland would be asserting his Fifth Amendment privilege against self-incrimination in the presence of each defendant currently on trial and each of their respective attorneys. Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and granted an order of the court pursuant to OCGA 24507, directing Copeland to testify and extending immunity for Copeland's compelled testimony. Glanville further explained to Mr. Copeland in the presence of every defendant currently on trial and at each of their respective attorneys that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Now, what she's trying to do is say any prejudice that happened in the ex parte communication was cured because all of these conversations happened in open court in front of all the defendants.
Right. It was harmless error.
Right.
We were talking about harm. It was harmless error. And the second thing is, it was Copeland's constitutional rights we're dealing with, not Williams or any of those defendants. So that's where they're going.
Mr. Copeland thereafter stated his intention to testify, and Mr. Melnick looked toward Mr. Steele and Mr. Shart and shrugged his shoulders. After, again, they're assigning motive there to the shoulder shrug.
I know it.
After motions hearings, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions. And when asked his age in years, Mr. Copeland responded, "I plead the fifth." The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland into custody in open in open court, in the presence of all the defendants currently on trial and in the presence of each defendant's respective attorneys. Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court on Monday, June 10th, to allow Mr. Copeland to purge himself of this contempt by testifying. Mr. Melnick, purge himself just means he can get out of prison, get out of jail. His sentence is gone. Contempt is gone if he just does what the court wants him to do. Melnick announced he was going on vacation, would in no way be present on Monday, would appoint standing counsel Kayla Bumpus to represent Copeland in court the following Monday. June 10th meeting regarding contempt proceedings initiated against Copeland upon motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, and Honorable Chief Judge Glanville. You know what she doesn't call it?
Ex parte.
Exactly.
Now, that's right. Look before.
Star chamber out there.
And look at the second line. She calls it an in-chambers meeting. It's no longer ex parte meeting.
On Monday morning, prior to the start of court, the state requested from the court an in-chambers meeting with counsel for Kenneth Copeland, the court attorneys for the state, to discuss the proceedings. Court granted state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. Present during the meeting were CDDA Love, Bumpus, investigators, Glanville, Copeland, and Hilton. Matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included Mr. Copeland's rights and representation as it relates to the proceedings, Mr. Copeland's obligations under OCGA 24507, and answers to questions posed by Mr. Copeland regarding matters related to that rule, such as the distinction between purging oneself of contempt as addressed by the rule and perjury as prohibited by the rule. With the exception of the times where Mr. Copeland was afforded an opportunity to speak with Ms. Bumpus alone, the entire meeting was taken down by the court reporter. So we don't know if that's true or not.
Well, I think I tell you right now, it's not true. I mean, just reading the transcript, there's no way the entire meeting is in that transcript.
Facts. Like we who have, even if that was our first transcript that we ever saw, we're like, this doesn't look like the full picture. Then you, of course, have the other professionals, the attorneys coming out like, this is not a full transcript. So to put yourself on record, to defend this judge and yourselves, to answer the claim, to say that the entire meeting was taken down by the court reporter, you have to prove that, I guess. It wasn't handed out if it was taken, but the father son is saying there's no way it was even taken down, or recorded like that. So, and I know it was probably recorded auditorily, possibly, but not in a transcript format, I think is what they're saying.
I mean, it starts out with Miss Love talking. I mean, there's no way.
Not just that, but we don't have to take her word for it, right? The defense attorney don't have to take her word for it. That's the problem. And that's why at this point, when there's a discrepancy and Bumpus is saying more was said, she's saying more wasn't said, it seems like if you read the transcript, more was said. How do you figure this stuff out? You swear them and you ask them questions, right? And you see what's conflicting testimony, and somebody decides at the end of the day what the truth is. So LB and a bunch of people are posting, this stuff happening in a bunch of cases is a little bit scary here. But that's why good defense attorneys are important. Whether you like them or not, you want them to fight for rights because they're fighting for the rights of people like Young Thug. They'll fight for your rights. And these are things that could affect you in the future in a case, because it's not just Georgia. It's not just Fulton County, right? We're seeing issues all over the place in all different trials with judges, with prosecutors, with law enforcement, and with defense attorneys sometimes. Brian Steele's defiance of the court's commands and subsequent contempt ruling. Here we go. After the meeting regarding Copeland's contempt and obligations, by the way, you're right. What they don't mention here is the emergency nature, why they needed to do it, anything like that. There's no reason.
Or the fact that Copeland had a safety concern. That's not mentioned in here. I mean, they've totally, again, I think it's the right strategy, by the way, but they've totally changed their strategy. And now the issue is that it's only Copeland's rights affected and nobody else's. Therefore, no one has a right to challenge anything that happened in this ex parte hearing. That's their theory, and I think it's the best one they've got.
The problem is, when you read this, it makes no sense why they couldn't have done this in front of the defense attorneys.
No, not at all.
Absolutely no sense. They almost make it seem like we had the same hearing behind closed doors that we already had in front of all the lawyers. So then why? That's not true. We know that's not true because you wouldn't have asked for an in-chambers ex parte hearing and meeting if you thought it was the same as what you've already done in open court, right? We all know that. Come on.
And they don't really justify why they asked for an in-camera hearing. They just say they asked for one. I mean, there's no real reason.
Right, exactly. All right, Steele stood up in open court and demanded a mistrial as he loudly and repeatedly hurled at the Chief Judge Glanville accusations of misconduct. Oh, he didn't just do it in court. He did it in black and white that we just read. Most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's commands to reveal Mr. Steele's source of the information regarding the in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt of court. After defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed his motion and supplement. I mean, this is, folks, like, some people don't like when you get your rights. Some people don't like when people stand up and fight for their rights. They want you to roll over. They want you to be controlled by them. They want to scare you. They want to use their power and influence and position over you. It happens.
I know that it may be hard to see, but if you look at this, you got to realize the state really had no axe to grind when it came to Steele being held in contempt. That was just between him and the judge. And Steele didn't answer the question. The judge held him in contempt. State had no involvement in that, yet they want to insert themselves because they want to, again, slam another defense lawyer and paint them as obstructionist and paint them as irrational.
And by the way,
they really had, they had no axe to grind with Steele.
And by the way, not all prosecutors are like this. So we're not saying every prosecutor's like this.
No.
We're not saying
I was a prosecutor and I was a wonderful guy.
I don't know if everybody would agree with that.
That's funny. I was a prosecutor. I was a wonderful guy. Okay. Well, how can I put it? Logically, maybe they don't have any reason to mention Steele defiantly still trying to answer the court, and that's why he got held in contempt. But if they're answering what Steele wrote first, I could see why they would try to bring something personal into it with his demeanor and stuff like that, because he was creative with his language on how he described them. I believe he tried to remain factual. So for them, they're probably going to try to take some kind of dig at him personally as well. I'm not saying that they were right, but I'm saying I could see why they would still try to bring it up.
I don't know if defense attorney would agree with that, but not all prosecutors, not all judges, not all law enforcement's like this. Okay. And that's why we're highlighting these exceptions, and we need to get rid of these exceptions or correct them. Right. And hopefully they can do better in the future. That's really the point of highlighting this and talking about this. And if you remember, we were a bit shocked at how respectful and calm Steele was throughout this entire process. He could have blown his gasket. The man was thrown in jail. He took off his tie in the middle of a trial to be thrown in jail. And he was pretty respectful and calm, I would say. Yeah. Somebody that's not as calm.
Even when he was being heading for the holding cell, he asked the judge permission to speak. I remember that. He didn't just blurt it out. He said, "Judge, can I say something?"
Yes, exactly.
The judge goes, "Yes." And he said, "Okay." And then he said something. He made another motion for mistrial. But, he was respectful.
All right. Argument and citation of authority. No fact set forth in the defendant's motion or supplement authorizes the recusal of the judge. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in this case. There is a presumption that a trial judge acting as a public official, again, as Mr. Steele would say, faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Here, with the exception of defendant Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for not being prepared, defendant's motion and the supplement are based entirely on the defendant's assertions regarding the June 10th, 2024 meeting, regarding the contempt proceedings against Kenneth Copeland and actions taken by Chief Judge Glanville and after Mr. Steele defiantly refused to comply with the court's repeated request to provide the court with information. Do you have something?
I was going to say, when you get down now to the, however, no defendant, capitalized, this is the key to their argument right here. In one sense, they synthesize what the argument is and what their argument is going to be for the judge to deny this motion.
Georgia Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person who has a legal interest in the proceeding or that person's lawyer the right to be heard according to the law. However, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceeding initiated on motion of the state involving Kenneth Copeland's refusal to testify. Since no defendant in this case had a right to be present at the June 10th in-chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Kenneth Copeland, the fact that the meeting provides no grounds for recusal of Chief Judge Glanville. All right, so go ahead. Explain why you think that's a good argument.
Well, that's the key. The key is, I don't care what happened in this case, they cannot file a motion because they have no standing to complain because their rights were not affected. The only person's rights that were affected in this in-camera, ex parte, whatever you want to call it, were Copeland's rights. So the defendants had no rights there. If they had no rights affected, then there is no recusal. They had no right to be in that meeting. Now, we've seen from Steele's motion that what they're saying was affected was their rights to Brady, cross-examination, all of that was affected by the fact that they couldn't be there. They never said the reason why the defense couldn't be there. That's not addressed in their motion. They never said why they asked for it to be in camera. They never justified any of that. And without any justification, I just don't see how the courts can say that that ex parte hearing was justified and that Glanville did the right thing. He's responsible. He's the judge. He should have said, okay, why are we meeting without the defense? Explain that to me and let me rule on that before we go any further and before I hear anything that might prejudice me.
And they have said that before. These attorneys have said that before. Like when the judge realized he was in an ex parte meeting, when he realized the defense was not present, and not the defendant, but the defense counsel was not present. And the fact that he didn't, and he probably never would have, in my opinion, he never would have, because he does have this comfort with prosecution. And as someone pointed out in other videos, he probably doesn't get checked. And so some things start to seem like he isn't doing anything wrong. And then in this one he got challenged on. But yeah, like he could have stopped the proceedings. They said the judge would not have been wrong had he just realized, okay, not everybody's here. We need to stop these proceedings. He also didn't make the affirmative statement that they were citing in a different case about how it didn't prejudice him against anything and stuff like that. Yeah, he didn't stop it. Not only did he not stop it, he was telling them they didn't have a right to know about it. Then they didn't have a right to the transcripts. They didn't have, all these things. And I just think, I don't know, is it pride or is it something else on why I would take myself off this case? Like, you know what? I am too close to this because there's some things I can't even see anymore through my bias. But this is not good. This is not good. You take yourself off of here.
Right. And I honestly think there's no way getting around the fact that Copeland made certain admissions and Judge Glanville and the prosecutors never did or even intended to let the defendants know about that. And I don't see how you get past that.
How about a question of Copeland? Mr. Copeland, why did you ask if you'd be immunized for murders? Were you worried about you might be indicted for a murder? What murder would that be?
There's all sorts of things in there that now that we know the content of the hearing, it's just, I don't see how you get around that personally. I just don't.
If you want to for fun, and again, I don't know if you want to or not, but the very first exhibit is the email from Melnick. I don't know if you want to read that email, but I think it's interesting email.
All right, we'll go through it quick just because we don't have a ton of time here.
I know we've been long, I know, but
My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything else besides protecting my client. And this was in response to Ms. Love saying, is your concern for your client or Mr. Steele and Mr. Shards?
Right. Well, good response.
I'm going to see if they're going to go through any more of that document where the prosecution or the state is answering Attorney Steele's motion. But if not, then we're either way, we're almost done. So let me just skip ahead a little bit. Okay, I think they're talking now. Great points made. We will keep up. And Shan said the judge was taking too long to answer one of the motions, I think. So we'll keep up with it. Keep our eye on it. We'll be back here for more YSL updates. I will see y'all all throughout this weekend, most likely. Thank you for joining me for this. I definitely appreciate your company and your input. And I will talk to y'all later. Bye.
I've been taking my time, taking all of your time, taking all of your time.